Members of the jury, at this time, the court will give you the legal instructions which you will apply in your deliberations. You will have all of these with you in writing in the jury room, so please don't feel like you need to try to keep up with me and take notes. I think your time will be much better spent if you just sit back and carefully listen. This will take about 20 minutes, and then we will move into the closing arguments of the attorneys. Members of the jury, now that you have heard the evidence, I will instruct you on the law which applies to this case. Although you as jurors are the sole judges of the facts, you must follow the law stated in these instructions and apply this law to the facts which you find from the evidence before you. Pay careful attention to all of the instructions that I give you. All of the instructions are important because together they state the law that you will apply in the case. You must consider each instruction in light of the other instructions, and you should apply them as a whole to the evidence. The order in which the instructions are given does not suggest that any one instruction is more important than any other. Do not concern yourself with the wisdom of any rule of law. Regardless of any opinion you may have as to what the law ought to be, you have sworn to base your verdict on the law given in these instructions. You have been sworn as jurors to try the issues of fact in this case. Both the parties and the public expect that you will carefully and impartially consider all of the evidence, follow the law in these instructions, and reach a just verdict regardless of the consequences. Keep constantly in mind that you cannot base your verdict on anything but the evidence in the case. Therefore, do not let bias, sympathy, prejudice, or public opinion influence your verdict. In considering the evidence, you are expected to use your good sense. Give the evidence a reasonable and fair construction in light of your common knowledge and experience. At times during the trial, I have ruled on objections to testimony or exhibits. These questions are questions of law for the court, and you must not concern yourselves with the reasons for its rulings. You should not be influenced by these rulings, and you must consider only the evidence which the court has admitted. In my rulings, actions, remarks, and instructions, I have not intended to suggest how I would resolve any of the factual issues in this case. In determining the facts of a case, you may properly consider two types of evidence. One is direct evidence, such as the testimony of an eyewitness. The other is circumstantial evidence, proof of a chain of circumstances pointing to the existence or non-existence of certain facts. The law makes no distinction between direct and circumstantial evidence, but simply requires you to find the facts in accordance with the evidence in the case, both direct and circumstantial. The credibility of a witness may be attacked by evidence that in the past the witness made a statement or acted in a way which is inconsistent with the testimony here in court. When a prior statement is offered to impeach the testimony of a witness, you can consider the earlier statement in deciding the credibility of the testimony here at trial, but not as proof of anything else. In limited circumstances, you may consider an earlier statement as proof of what the speaker said in the earlier statement. Specifically, you may do so if 1. The statement was made by plaintiff or by one of the defendants, or 2. The witness testified during the trial that the earlier statement was true. Statements, arguments, and questions of attorneys are intended to help you understand the evidence and apply the law, but generally they are not evidence. Only the witness's answers and the items received as exhibits are evidence. When the attorneys agree on a certain fact, however, the agreement is called a stipulation. When the attorneys have stipulated to a fact, no other proof is needed, and you must accept the stipulation as true. The parties have stipulated to the following facts. 1. Terry Bruner had been diagnosed with cirrhosis of his liver and hepatitis C from at least February 9, 2006. 2. As of March 5, 2008, The liver disease had compromised Terry Bruner's immune systems and made him susceptible to, among other things, streptococcal pneumonia, sepsis, pneumonia, and meningitis. 3. As of 7 o'clock a.m. on March 10, 2008, or sometime before, Terry Bruner was suffering from illness that either led to or resulted from streptococcal pneumonia, sepsis, pneumonia, and meningitis, from which he ultimately died. 4. Streptococcal pneumonia, sepsis, pneumonia, and meningitis are serious illnesses, and therefore, as of 7 a.m. on March 10, 2008, Terry Bruner had a serious medical need. The evidence consists of the sworn testimony of the witnesses, no matter who called them, the exhibits received in evidence, no matter who produced them, and any facts which are admitted or stipulated. You must disregard any evidence to which the court sustained an objection. Likewise, you must disregard anything you may have heard or seen outside the courtroom. You can only consider the evidence, but in considering the evidence, you are permitted to draw such reasonable inferences as seem justified in the light of your experience. During the trial, you have heard and seen deposition testimony, which consists of sworn recorded answers to questions to a witness before trial by one or more of the attorneys to the case. The testimony of a witness who for some reason cannot be present to testify from the witness stand may be presented by a deposition taken under oath. You should give such testimony the same consideration, and insofar as possible, consider it in the same way as if the witness had been present and had testified from the witness stand. Ordinarily, the rules of evidence do not permit witnesses to testify to opinions or conclusions as to which the witness does not have first-hand knowledge. Expert witnesses are an exception to this rule. Witnesses who by education and experience have become expert in some art, science, profession, or calling may state opinions on matters in which they profess to be experts and may also state their reasons for the opinion. You should give expert opinion such weight as you think it deserves. If you decide that an expert opinion is not based upon sufficient education or experience, or if you conclude that the reasons given in support of the opinion are not sound, or that the opinion is outweighed by other evidence, you may entirely disregard the expert opinion. Burden of proof means burden of persuasion, and is sometimes referred to as establishing something by a preponderance of the evidence. Plaintiff must persuade you that her claim is more probably true than not true. In determining whether plaintiff has met this burden, you will consider all the evidence, whether produced by plaintiff or by defendants. The weight of the evidence on any issue is not determined by the number of witnesses, but by how reasonable, persuasive, and satisfying the evidence is to you. Instruction number 10 sets forth the claims and the positions of the parties. Plaintiff, the estate of Terry Bruner, through Tera M. Bruner-McMahon as administrator, claims that Mary Staton and Marque Jameson violated Mr. Bruner's constitutional right to be free from cruel and unusual punishment while in jail. In particular, plaintiff claims that on March 10, 2008, defendants Mr. Bruner's serious medical need, in that despite his obvious need for immediate medical attention, they made no effort to obtain medical attention. Plaintiff claims that on account of the violation of Mr. Bruner's constitutional rights, he suffered unconscious pain, suffering, and mental anguish. Plaintiff seeks to recover $10 million for Mr. Bruner's conscious pain, suffering, and mental anguish. Plaintiff also seeks punitive damages in the amount of $1 million from each defendant. Plaintiff has the burden of proving that her claims are more probably true than not true. Each defendant denies plaintiff's claims. Plaintiff's claim is predicated on a federal civil rights statute, Title 42 of the United States Code, Section 1983, which imposes liability on county officials who unlawfully deprive someone of rights secured or protected by the United States Constitution. The 8th and 14th Amendments of the Constitution protect prison and jail inmates from cruel and unusual punishment, which includes deliberate indifference to an inmate's serious medical need. To establish her claim as to each defendant, plaintiff must prove that each of the true than not true. 1. By 7:00 a.m. on March 10, 2008, Terry Bruner had a serious medical need. 2. Defendant knew of a substantial risk that Mr. Bruner had a serious medical need. 3. Defendant consciously disregarded that risk by failing to take reasonable measures to address it. And 4. Defendant's actions injured Terry Bruner. As to the first and second elements, a serious medical need includes a situation where denial or delay in medical care creates a risk of permanent physical injury, death, or needless pain and suffering. It also includes a medical problem that is so obvious that non-doctors would easily recognize the need for prompt medical attention. As to the second element, if you find that defendant refused to verify underlying facts that he or she strongly suspected to be true, or declined to confirm information about a risk that he or she strongly suspected to exist, you may conclude that defendant actually knew of a risk that Mr. Bruner had a serious medical need. Also, if you find that Mr. Bruner's risk of a serious medical need was obvious, you may, but are not required to, conclude that defendant actually knew of that risk. On the other hand, you may find that defendant was not aware of a risk, even where it was obvious, or that defendant knew of the underlying facts, but believed, although incorrectly, that Mr. Bruner did not have a serious medical need. In that event, you should not find that defendant had the required knowledge under the second element. Your verdict as to each defendant must be determined from that defendant's own conduct and from the evidence that applies to that defendant, just as if that defendant were the sole defendant. You must give fair and separate consideration to the claim against each defendant. Generally speaking, it is hard to prove intent through direct evidence because there is no way of fathoming or scrutinizing the operations of the human mind. You may draw certain conclusions about a person's intent, however, by looking at surrounding circumstances. You may consider what a person said or did not say, what a person did or did not do, and all other evidence which indicates his or her state of mind. You may consider it reasonable to conclude that when a person knowingly does or does not do something, the person intends the natural and probable consequences of those acts or omissions. If you find in favor of plaintiff on her claim against one or both defendants under instruction number 12, you must determine the amount of plaintiff's damages. You should allow plaintiff such amount of money as will fairly and reasonably compensate her for any damages which were proximately caused by defendant's violations of Mr. Bruner's constitutional right to be free from cruel and unusual punishment, which includes deliberate indifference to his serious medical needs. You may award plaintiff compensatory damages for any conscious pain, suffering, and mental anguish that Mr. Bruner sustained as a result of defendant's unlawful conduct. No evidence of monetary value of such intangible things as pain, suffering, and mental anguish has been or needs to be introduced into evidence. In determining the amount of damages, you should be guided by dispassionate common sense. You must use sound discretion in fixing an award of damages, drawing reasonable inferences from the evidence. No exact standard exists for fixing the amount to be awarded for compensatory damages. Any award must fairly compensate plaintiff, but it must have a basis in the evidence and be reasonable in light of that evidence. If you award damages, your award must be fair compensation, no more and no less. The burden is on plaintiff to prove by a preponderance of the evidence the existence and amount of her damages and the fact that they were approximately caused by defendant's unlawful acts. You should not add to or subtract from any award of damages on account of plaintiff's contract with her attorneys for attorney's fees. This is a matter for the court to decide. If you find from a preponderance of the evidence that plaintiff is entitled to actual damages against one or both defendants, you may, but are not required, to award punitive damages. Punitive damages may be imposed to punish the wrongdoer for extraordinary misconduct and to serve as an example or warning to others not to engage in such conduct. To award punitive damages, you must find by a preponderance of the evidence that a defendant acted with malice or reckless indifference to the federally protected right of Mr. Bruner to be free from cruel and unusual punishment, which includes deliberate indifference to his serious medical needs. Malice is a state of mind characterized by an intent to do a harmful act without a reasonable justification or excuse. An act is maliciously done if prompted or accompanied by ill will, spite, or grudge toward the injured person. An act is done with reckless indifference if it is done in reckless and callous disregard of or indifference to the rights of the injured person. Punitive damages must bear a reasonable relationship to Mr. Bruner's actual injury. However, no single numerical equation easily links punitive damages to actual damages. In determining a reasonable relationship to the actual injury, you must consider all of the relevant factors, including 1. The nature of defendant's conduct under the totality of the circumstances, 2. The frequency of defendant's conduct, 3. How reprehensible defendant's conduct was, 4. What amount of punitive damages, in addition to the actual damages already awarded, is needed, considering defendant's financial condition, to punish defendant for his or her wrongful conduct toward Mr. Bruner and to deter defendant and others from similar wrongful conduct in the future, and 5, whether the amount of punitive damages bears a reasonable relationship to the award of actual damages. The third element, the degree to which defendant's conduct was reprehensible, is the most important factor to consider in deciding whether to award punitive damages. In determining the degree of reprehensibility of defendant's conduct, you should consider whether defendant caused physical as opposed to economic harm, whether defendant's conduct evidenced an indifference to or a reckless disregard for the health or safety of others, whether the target of defendant's conduct was vulnerable, whether defendant's conduct involved repeated actions or was an isolated incident, and whether the harm caused was the result of intentional malice. Any award of punitive damages must be fixed with calm discretion and sound reason, and must never be awarded or fixed in amount because of sympathy, bias, or prejudice with respect to any party to the case. To find defendant liable, you must find that defendant directly injured Mr. Bruner or played a substantial part in injuring Mr. Bruner, or that Mr. Bruner's injury was a reasonably probable consequence of defendant's conduct. In other words, you must find that defendant's conduct was the proximate cause of Mr. Bruner's injury. This does not mean that the law recognizes only one proximate cause of an injury or damage, consisting of only one factor or thing or the conduct of only one person. On the contrary, many factors or things or the conduct of two or more persons may operate at the same time, either independently or together, to cause injury or damage. In such a case, each may be a proximate cause. If you find that the conduct of each defendant was the proximate cause of all of plaintiff's damages, you may award damages against each defendant in the full amount of plaintiff's damages. The fact that I have instructed you on the measure of damages does not suggest that I think plaintiff is entitled to your verdict in this case. I have included damage instructions in case you find for plaintiff from a preponderance of the evidence under the other instructions. You are the exclusive judges of the factual issues, the weight of the evidence, and the credibility of the witnesses. You may and should, however, take into consideration the general information which you possess as to matters of common knowledge, observation, and experience of life. In weighing the testimony of the witnesses, you may consider their demeanor while testifying, their interest or lack of interest in the outcome of the case, and all other facts and circumstances which will help you decide the facts of the case. You will decide whether to believe a witness, and in evaluating a witness's testimony, you may want to ask yourself the following questions. 1. How well could the witness see or hear the things that the witness testified about? 2. How well was the witness able to remember and describe what happened? 3. Did the witness understand the questions and answer them correctly? 4. Did the witness seem believable to you? If you believe that any witness has intentionally given false testimony on any material fact, you may disregard all or part of his or her testimony, but you are not required to believe or disbelieve all the testimony of any witness. If there has been conflicting testimony, you should reconcile it with truthfulness if reasonably possible. But if you cannot do so, then you must use your best judgment in determining what testimony you will believe. People often forget things, or they may honestly believe that something happened even though it later turns out that they were wrong. Inconsistencies or discrepancies in the testimony of a witness or between the testimony of different witnesses may or may not cause you to reject such testimony. Two or more persons witnessing an incident may see or hear it differently, and innocent misrecollection, like failure of recollection, is not an uncommon experience. In weighing the effect of a discrepancy, always consider whether it pertains to an important issue or an unimportant detail, and whether the discrepancy is innocent or intentional. Your verdict will consist of answers to questions set forth in the verdict form. Your verdict must be unanimous. In other words, to return a verdict, each of you must agree to it. If you do not reach a verdict, the parties may be put to the expense of another trial, and once again have to endure the mental and emotional strain of a trial. If the case is retried, a future jury must be selected in the same way and from the same source as you have been chosen, and we have no reason to think that a future jury would be more competent or that evidence produced at a future trial would be more clear or substantial. You must consult with one another and deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after impartial consideration of the evidence with the other jurors. In the course of your deliberations, do not hesitate to re-examine your views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. You are judges, judges of the facts. Your sole interest is to ascertain the truth from the evidence in the case. Counsel, are there any objections to the instructions which the court has just given?
None other than have been already articulated, Your Honor.
Thank you. So, members of the jury, at this point we are going to move to the closing arguments. As you know, these arguments are not evidence in the case, but I think you will find that they are extremely helpful in jump-starting your deliberations. Each side has 40 minutes for argument, and we're going to go straight through and hear all of the argument before we recess for lunch. Plaintiff does have an opportunity to divide her time because she has the burden of proof. So plaintiff can defer up to 1/3 of the time which is allotted to her. And Mr. Feiger, you can proceed.
Good morning again, ladies and gentlemen. Morning. I'd be lacking in ordinary, just common courtesy if I didn't take the opportunity right now to thank each and every one of you for being here and listening to this case and giving us the opportunity to present it to you. And I sincerely want to hear what the defendant, Mr. Chalmers, on behalf of the defendant, says. And I hope he'll allow me to speak and give me the same courtesy and not object. I told you when I started this case, I came right out and told you that I was nervous and I'm afraid. And I'd be not being forthright with you if I told you that I wasn't still nervous and afraid. And why? Why am I afraid? Because this is the most important time of the trial. Your decision today, or whenever you render it, will be the story's ending. And I pray for a happy ending and a righteous ending. And I wonder if I've done my job well enough. And I know it's too late for me to turn back. If I had to do it over again, I'd probably be more kind to Mr. Chalmers, who I know is only doing the job he's retained to do. I would have listened more closely to Her Honor, because I know she's only attempting to see that the parties get a fair trial. If I had to do it over again, I think I would have done a better job in presenting my case. There were questions I failed to ask, and I'm afraid that I haven't done a good enough job. On the other hand, I'm eager to talk with you now, for this is a special time that I have with you. I've been waiting over 2 years for someone to hear this case. Mr. Chalmers wouldn't hear me or listen. He only filed motions to keep me from getting here. His clients wouldn't listen to me. They turned a deaf ear and a blind eye to Mr. Bruner. After all, he was just a poor, drunk Indian. And they just repeat this falsehood. We didn't know. I put it on a board when I first spoke to you. We didn't know, so please let us go. That's their mantra. That's the falsehood. We didn't know, so please let us go. No one has listened in this entire case except you. Thank God. Now, we've waited these long years to be heard, and finally, we're here. Mr. Bruner, in a real sense, gave his life for this opportunity. So did all of those who have given their lives for the constitutional rights and freedoms that we Americans say we hold so dear. You know, I carry it around in my pocket. It's really a small document. It's what controls and sets the rules for our country. It's what we're trying this case under, the Eighth Amendment to the Constitution of the United States. Really says very little. And it only has the meaning that we give to it. So I'm eager to make these statements to you because in the end, you're the only persons in the world who will hear us and who can finally render, what is it? Justice. Remember, justice is a feeling. It's born of a need for retribution bursting out of the deepest recesses of the human condition. It comes from a pain that's been fueled by loss or a fear or suffering. And it's responded to within the limits of our meager ability to provide justice. No amount of money can undo the pain, the agony, the anguish, and the suffering that was inflicted here upon a human being, and which was silently endured in that God-forsaken cell. Now we who are charged with the task of obtaining justice do the best we can with our limited tools. In this moneyed society, we're only permitted to render money judgments for those who have suffered and against those who have caused inhumanity and suffering. But it isn't complete justice. Complete justice could only be realized if we could undo this terrible wrong, if we could erase it, in which sadly we can't. It's now perhaps the best time to understand in a real sense who the heroes are in this case. It's you. A great gift has been given to us. To you. Most of us live our lives and never, ever have an opportunity to make a real difference in life. What a great gift if we ever have the opportunity to make a difference. Most people never get that opportunity. Many of us don't even know we've been given such a power, that we've ever been given an opportunity such as we have here to make a difference. And even when it's in our hands, we don't realize we have the power to make a difference. In this case, it will very, very soon, finally, be in your hands. So what's justice? What's the suffering and anguish of a poor man worth? Like I said, Mr. Bruner, in a very real sense, has given his life so that we might now have the opportunity to loudly say, so that everyone can hear by your verdict, never again. Now, your verdict is a historical record. It's being kept word for word. The arguments that we make here in court, the law, the judge's ruling, the instructions, and eventually what you say about what you heard in these few days in February and March of the year 2012 will be looked upon by generations, hundreds of years into the future, can look back and say, in a courtroom in Wichita, Kansas, how did Americans in that year define justice? And how did they respond to the type of inhumanity that you have heard in terms of the evidence in this case? Now, I said before, this is a moneyed society. We won't stop this inhumanity for $1 million or $10 million. But the only thing, truly the only thing they understand is money. So it must hurt them in their pocketbooks. That's all they understand. That's why we have punitive damages. I asked each and every one of you in the voir dire. It was the only opportunity that any of us had to talk to you and to ask you, do you have, if this case of inhumanity beyond human comprehension is proved, do you have a limit? Or do you have a cynicism Are you hiding something? Each one of us could say, Mr. Feiger, Mr. Chalmers, Judge, yeah, I want to tell you how I really feel. When you took your oath, each of you swore to follow the judge's instructions, which the court just gave you, and they are simply the roadmap to this case. Follow those instructions and justice will result. No, there's no two buts about it. There's no lawyering here. There's no innuendos. There's no loopholes. It's as clear as anything. In the opening statement, I promised you, I came before you because it's about my credibility. I stood before you and I looked each of you in the eye and I said, I promise, here is what I will prove. I promise you, at the conclusion of this case, I will come before you again and I will look at you and say, I have kept my promise. And I did. I want to show you two things in terms of the evidence. You heard the evidence. The evidence here is not only overwhelming, it's an avalanche. But two pieces of evidence really struck me. They occurred last week. They were both presented by the defendants in this case. Dr. Petrie came here, and I have a great deal of respect for him because he would not be a pawn, and he did not come here to be a pawn. He is a respected physician at the University of Kansas in infectious disease. And I asked him these questions. This is a record. This was testified to in court. The court reporter, if asked, allowed it, produced just a couple pages of it, and here's what I asked. Dr. Petrie, and to your knowledge, in terms of the medical records, he had been locked in a cell for the entire 5 days he was in Sedgwick and had received no treatment whatsoever, had he? Answer, that's true. That's inhumane, isn't it? Yes. Yes, of course it is, because if you did this in your hospital, you'd call the police, wouldn't you? Yes. Now, I don't know if you were listening because I sometimes find it hard to listen to depositions, but the defendant also read a deposition of a gentleman, you heard of Mr. Nichols, who was in on the transport, who recognized that Mr. Bruner was sick at Staton, and then arranged for him, along with Mr. Shepard, to have him transferred back 5 days before he died while he was locked in that cell. The defendant read the deposition of Mr. Shepard because he is a long way away and he couldn't make it here. And he said two things that are this case. It is so crystal clear about this case. These were read to you in open court. When you looked at these inmates complaining about having the flu, did they appear to be sick? If they did have the flu, he said, yes, sir. And then he was asked about Mr. Bruner. And this is now 6 days before Mr. Bruner died. You remember him laying in bed? Answer, just laying on the bed, yes, which they all did. Did he appear to be ill? Yes. And what about him for you to think that in your mind that this looks like an ill person? And he said, common sense. Now, that's all this case was ever about, common sense. Whether two people who hide behind a badge can walk in front of a federal court jury and a federal court judge and say, I didn't know, so please let me go. I didn't know what obviously anyone could see. I thought about it before. That's their defense, the ostrich defense. That's it. So what are the truths here? What have we learned? We say we didn't know, so please let us go. Here's what we've learned. I believe that if they can do this to Mr. Bruner and get away with it, then they could do it to any one of us and get away with it. Power produces arrogance. I hear every day, I watch the news, I watch the TV, every day about how we have too much government. Well, here's a perfect example. This is government. Power corrupts if we don't keep it in check. We don't bow to the government. The power comes from us, the people. We, the people. The basis of our constitutional rights. This isn't just lip service. This is the real thing. We, the people, we hold these truths to be self-evident, that all men are created equal, and that they are endowed by their Creator with certain unalienable rights. That means rights that can never be taken away. among those life, which we're dealing with here. Life, liberty, and the pursuit of happiness. The only thing we decide today, factually, is are these two jailer defendants deliberately indifferent? Everything else has been admitted. And as to that, ladies and gentlemen, it was so obvious that it became embarrassing. There is no way they could not have known. They saw it, and they admitted it. They heard, and they admitted it. They were told, and they admitted it. And yet they did nothing. Now that is about as cruel and as inhumane and as deliberately indifferent as it ever gets, ever. Can you think of anything more inhumane, more cruel, more calculated to cause human suffering? Could any fair or reasonable person, and the judge said about reasonableness, could any fair or reasonable person say they didn't know? Can anyone think of a more clear act of betrayal to a victim, to his family, to our country, to our Constitution? Can anyone think of locking someone in a cell while they're desperately sick until they die, of being more inhumane? Putting a dying man into a cell, lock the door, and then slowly let him die and say, I didn't know, so please let me go. And they told the inmates who were begging them to get him help, he's faking. And you saw how they treat the inmates. You saw how they treat anyone who comes here with the truth. This is the ultimate act of betrayal, because it betrays not only Mr. Bruner, betrays our constitutional rights. It's what makes us a people, if they can do this. The judge said, think about whether it is reprehensible, the behavior, in order to punish them. Can you think of anything more reprehensible? Even if you wanted to, you and I, or no one else in this country, could take the worst murderer, the worst serial killer, and do what they did to Mr. Bruner in that cell. That would be unconstitutional and cruel and inhuman. And they did it to someone here who was locked up for drunk driving. And if they can do it here, and they can do it with your permission, who would ever stop them? And there's no way they couldn't have known. The ostrich in the sand defense. And our system of justice cannot tolerate ostriches. They say, we didn't know, so please let us go. Now, can anyone prove what someone falsely claims they didn't know? Especially when it was obvious they did know. Now, I guess you could run into someone with a car and say, I didn't know I hit you. No one would believe you, but the courts are full of people making that ridiculous defense. Full of them. Every single day you read about it. I guess you could pull the trigger on a gun and say, I didn't know I shot you. But no one would believe you. You leave a man laying in a cell, not for a minute, not for a half an hour, but for hours and hours and hours while he's dying. You say, I didn't know. No one would believe you, unless the laws of science and the laws of human behavior are somehow suspended here in this courtroom. And if you wear a badge and you work at the Sedgwick County Jail, you can get away with murder. Why do they think anyone would believe that they didn't know what they obviously did know? Why do they think anyone would believe what they obviously saw? And by God, it was their job. It wasn't simply they were passersby. It was their job to know. That was their job. That was the reason they were there, to protect the safety and the health and the welfare of those who were under their control, who were locked up and under their care. It was their job to protect the people who are totally helpless and dependent upon them for everything. They did know. I'm going to show you something that was never, ever, ever shown to you in this case, ladies and gentlemen. This record was obviously shown to you, but of course the defendants never made a point of it, from 3-5, showing that Mr. this is from Sedgwick, was sent over from Staton, and he's saying 5 days before he died, "I'm weak, not eating a meal for 2 days, blood in the stools." Okay? Now that's when he arrived. But when he died, and these defendants say, "I didn't know." Everyone knew. Everyone knew. And he's brought lifeless and brain dead to Via Christi Hospital. And he's transferred there by the people who did this to him. And everyone knew what had happened to him. This is from the Via Christi records that Mr. Chalmers and none of the defendants point out to you. This is a patient, a 46-year-old gentleman who's transferred from Sedgwick for decreased mental status. It seems he's not been feeling well and had been ill for the last few days with questionable fever and chills. He recently stopped eating and went to the clinic where he was seen by a PA over there. They knew, everyone knew. Everyone knew. When he comes there lifeless and the doctors over there start asking the questions for the first time, what's been going on? What did you do to this man? Where has he been? And that's when they got the answers. These are in the records from Via Christi Hospital, and you never saw them because it doesn't stop with these two jailers. This was a systemic wrong and a systemic cover-up. These two defendants did what they did because they thought they could, and that no one would ever do anything to them, and that the powers that be would cover up for them, and that there would be a conspiracy of silence, because this is really a case about all of us. Not just the two jailers, but about all of us. Our jails, our country, our government. And we, the people, this case is about whether we, the people, will tolerate such abuses in a civilized society. You are those people. And you have been given the opportunity to say no. I'm here from Michigan because if justice isn't done in this case, then they have a license, I believe, to kill us all. That which you do to the least of my brothers, you do unto me. They not only betrayed our trust, they betrayed their sworn duty, which they're sworn to support and uphold the Constitution and laws of the United States. And I hear people say to me all the time, but Mr. Feiger, these are hard times. We're all sometimes faced with hard times. Mr. Bruner faced his hard times in an inhumane way. He faced inhumane pain, suffering, and agony inflicted on him in a most cruel and sadistic and senseless way. His damages are $10 million as to each of the defendants. I won't argue why. We all know why. Could have been 50, it could have been 100. But maybe justice in this case will be $10 million as to each defendant, and $2 million, $1 million apiece for punitive damages. Not too much, but enough to say we understand the pain. We as a people, we the people understand the horror and the nightmare that we all heard too much about in this courtroom. And rich or poor, we all have our hard times. The life of Mr. Bruner was taken from him. He had a pre-existing liver disease. He was in jail for drunk driving. And if anything, we know that someone with a pre-existing disease is more susceptible to catching colds or the common flu. You protect them more. You don't treat them worse than a stray dog and then lie about it. They knew he was sick. They absolutely knew he was sick. And these defendants are the people's officers. They're still there in the jail. And but for the grace of God, go we. They'll do it again, they said, if they're not stopped. They told us as much. And how many times, ladies and gentlemen, how many times did we hear in this courtroom, I do not recall. I thought I was at a congressional hearing. I do not recall. That's the standard line. How many times did we hear that? Now they must hear you say never again. The powers that be must hear you say never again. It was their job to protect the health and the safety of those under their care. We send them our brothers, our sisters, our wives, our husbands, our sons, our daughters. They can't inflict this inhumane treatment on them. So how do we stop it? We stop it not by being like them, but by being fair and just. We stop it now, not by taking them to some dark room and giving them the same treatment. We stop it now instead by finding a just sum that must be paid for their evil injury. They were evil, and now we will be fully just. I've said 10 million as to each defendant, 10 million against each for the pain, the suffering, the anguish, the terror, 2 million, one each as to each of them to serve as a warning to others. Never again, as the court instructed you, to engage in this reprehensible behavior. Mr. Bruner, ourselves, our country, our Constitution, was betrayed by these jail guards, but he was not alone. As I indicated to you, our country and our Constitution has been betrayed. And throughout this entire trial, they lied to you, as you give of yourself, simply trying to be just and honest. Can they be permitted to inflict this pain, this type of cruelty upon others, lie about it in court and get away with it? The conspiracy of silence must end. We must make this country safe for all those in our hard times. All it takes for evil to prevail, silence. All it takes for evil to prevail, silence. I'll tell you one last story. I always end my closing arguments with a story. There was a wise old man and a smart aleck kid. Smart aleck kid was absolutely intent upon fooling that old man and getting the better of him, because to show him up and to show him that he wasn't so wise. So he thought and he thought and he thought about it. And he was going to devise a plan to fool that old man, to show that old man what a fool he was and that he wasn't so wise. And here's what the plan was. He would take a bird and he would show it to the old man. And then he would say, and he'd put the bird behind its back and say, "Old man, now, is the bird alive or is it dead?" It was a foolproof plan, because if the old man said, "Young man, the bird is alive," he'd crush the bird to death and say, "Look, old man, you fool, the bird is dead." And if the old man said, "Well, the bird is dead," then he'd say, "Look, let the bird go, fly away. Say, 'Look, you fool, the bird's alive.'" A foolproof plan. So he takes the bird to the old man to show him up, puts the bird in the face of the old man, now says, "Old man, I have a bird behind my back. Now you tell me, is this bird alive or is it dead?" The old man looked at him for a long time, studied a long time, and said this, "Son, bird is in your hands." Case, ladies and gentlemen, this day in March 2012, this case, this most important of cases. I want to thank each and every one of you so much for what you're going to do in the jury today, for the opportunity to have this day in this temple of justice. And therefore, I transfer to you right now years, the months, and the days that I have shouldered the responsibility of this case, this right, and this Constitution. I transfer that responsibility to you. Simply ask one thing, that you shoulder it with the same sense of justice, passion, that all of us should share under the Constitution of the United States in this temple of justice. Thank you very much.
Mr. Chalmers.
Try to get this out of the way. My wife's watch here. I think I'll try to stay within time. Are we ready? Morning. Good afternoon, almost. I think it's important to talk about what a case isn't before you talk about what a case is. This is not a case in which anyone has ever said, hey, look, this is a poor, drunk Indian. Let's put him in a cell and let's ignore him. That's offensive. The only time Indian came up that I remember had to do with when we showed a relationship between some of the inmates who knew the family members who had served in jail with Mr. Bruner's relatives and may have had a bias. Not anything about that sort of behavior, and it's offensive to the people. Now, this is also not a case against the sheriff. It's not a case against the county. It's not a case against the government. It's a case against two people. It's a case against these two people who you saw on this witness stand, and you'll be able to measure a little bit what their character is against the standards that the judge gave you. It's also not a case about $10 million to try to punish the system. It's a case, if you want to talk about damages, then you'd have to look at the instruction and they would talk about, well, if there is a period of time that Mr. Bruner was laying in his cell, was untreated because of their conduct, what was his suffering? How do you compensate him for that? And there's really no evidence on that. But it's not a case about damages. It is a case about justice. You see, I've been waiting 2 years to be in front of you folks, and I too share Mr. Feiger's sentiment. The role that you serve is extremely important, and thank you for doing it. You see, from an individual standpoint who's been sued, well, anybody can be sued, it's not until you get it to the jury that you have the bird in your hand, if you will, in order to have your conduct measured, in order to put an end to the tarnish on your reputation, in order to show that, in fact, you don't have any liability. Now, the judge says in an instruction, well, actually, this is what the case is about. I guess we ought to talk about that first. It's plaintiff claims a violation of Mr. Bruner's constitutional right caused him conscious pain, suffering, and mental anguish. And the judge gives you the instructions. Remember in voir dire we talked about this almost painful length, that the judge would tell you what the law is and that you would then apply the law and you would decide the case, that you would decide what the facts are, the judge would decide what the law is, and in fact the judge tells you, don't concern yourself with the wisdom of the rule. But figure out here, when we're talking about a constitutional claim, I'm not talking about whether someone could or should have done something different. When you're talking about a constitutional claim, you need to apply that rule. So, if that's what we're obligated to do, then what in fact is the rule? And the judge gives you a lot of instructions, all of which are important. You'll have them to read and study. But the one I think that you might use, you don't have to do it this way, but the one that you might use as kind of your template to figure out how do I decide this case is instruction number 12. Because that's where the judge tells you in instruction number 12, this is what plaintiff has to prove. Not what they stand up and say they've proved. but what they prove with evidence in the case. So plaintiffs must prove each of the following. One, that Mr. Bruner had a serious medical illness, and he did. Nobody disputes that. Never disputes. Two, that the defendant knew of a substantial risk. We did not know, let us go. That's the law. They have to prove they knew. And if it didn't know, it's not a constitutional violation, because the Constitution is about cruel and unusual punishment. It's not about mistakes. It's about deputies who knew that there was a problem and then consciously disregarded it. It's not about what they could have done, should have done, might have done, maybe knew, could have known. Because it's cruel and unusual punishment we're talking about. Now, in another case, maybe against another defendant, maybe it is about what they could have done, what they should have done. And if you want to know what it is the sheriff's office decided to do, how they decided to address this issue and make sure it didn't happen again, there in Plaintiff Exhibit 2, there is a document that called Lieutenant Moore's investigation. It goes through what happened, sets it out in detail from beginning to end, and gives their recommendation. He said, here's how we'll address this. Read it if you'd like. But that's not what this case is about. It's about these two individuals. And the first thing that they have to prove is they knew a substantial risk. Then they have to prove conscious disregard, and then they have to show that their behavior injured Terry Bruner. Now, here's an important point as to the second element, this had to know, or knew, rather. The important point is down at the very bottom. You see, if it's obvious, then you can circumstantially figure if it's there to be seen, well, they're not going to admit it necessarily. So if it's there to be seen, they must have known. And you might be able to conclude, and that's what the judge tells you, you can conclude. If it's there to be seen, if it's obvious, if everybody knew it, you might be able to conclude that's what they thought. But the important part, if you find the defendant was not aware of the risk, even where it was obvious, or the defendant knew of the underlying facts but believed, although incorrectly, that Mr. Bruner did not have a serious medical need, in that event, you should not find that the defendant had the required knowledge under the second element. You do not prove they knew there was a substantial risk. Now, instruction 12, let's talk about that in a little greater detail. Again, it's not about what they could have known. It's not about what they should have known. It's not about what they would have known. It's not about if they had done more checks, as the former deputy who was fired just talked about. If they had looked at him more frequently, what would they have learned? And, maybe you think it's wrong that the system out there says that you shouldn't look at him so frequently.
What is that on the screen?
Your Honor, that's my arguments, things I'm putting up there to talk about.
Would you take it off the screen because it looks like it's part of my instruction?
Oh, I apologize, Your Honor. I can clarify that. It's a discussion of instruction 12. And I didn't mean to imply that. Here, I'll take it off so it doesn't even say instruction 12. Instruction 12 is this document, and not this. But my point is, under that instruction, you have to know. And so it's not even if they could have found out. It's not even if there are medical records in place that they could have read. They couldn't. It's what they actually knew. That's what you tested against, and what they believed. And that's the important point, I think, of this last part. It's what they believed. Well, let me go before that. It's not even whether or not it's a big problem. I can't think of anything more serious than someone dying. But just because they've died, that's not the standard. We've all heard of, and I don't think any more serious about this either, or tragic than this, of a parent pulling out a car and running over their toddler. Do we say they're deliberately indifferent because they killed their child? It's what these people believed ends up being important, because that defines what they know. Let me give you an example. The day before yesterday, my 5-year-old grandson took the scissors that have the rounded ends on them and so forth, they're supposed to be safe, and decided that his sister, who's 2 years old, needed a haircut, and cut it down pretty much down to the root. So now she's got a bob. He believed that was okay. He thought that was fine. It's what he believed. He didn't know. So what is it that they believe? What is it they know in this case? First of all, it's agreed that Terry Bruner had a serious medical need. It's stipulated that he was actually sick. It's agreed that he was obviously sick by the time he was on the floor of his cell at 2 p.m. And actually, a little bit after 2 is when they got in there, but in that time frame. Nobody's saying that he wasn't obviously sick at that point. In fact, I think that's what Dr. Petrie talked about. It's also clear that he did not have pneumonia, sepsis, or meningitis yet. That's what Dr. Petrie talked about. That's what we know from listening to the physician assistant Fletcher. That's what we know from Dr. Kirkpatrick, that he had those liver conditions that their experts didn't want to talk about. And those liver conditions, however, had not reached this critical mass stage. And what we also know is whether or not it was obvious really doesn't decide this case, and that's what we just talked about. What did the defendants know? Well, what did they believe? They believed that there was no emergency, that they didn't need to get someone down there right away. They believed that it was a mental health issue and that mental health could handle it. They'd seen inmates like this before. And they did things consistent with that. They thought that we were really dealing with a suicide, potential hunger strike, and that they were dealing with it appropriately. And how do we know that best? Well, there's the report in Plaintiff's Exhibit 2 from Sergeant Johnson Wooten. It's dated the 10th. Whether she dictated it off early morning the 10th, late morning the 10th, or whether it was early the next day, what does she say? She says, I was contacted by mental health as they exited Pod 1. Mr. Bruner was in the pod, as reported by the first shift, had not eaten, and was not coming out of his room. So they went to visit him, make sure he was not on a hunger strike. They wanted them to be visited, make sure he was not on a hunger strike suicidal. So what is this conspiracy of silence? Not only is there a conspiracy of silence, however believable that is, but now you have someone who is documenting things at the time to forward that conspiracy of silence. That doesn't pass the smell test, folks. What they believed, what they knew is right there in black and white. It is that they thought he had a mental health issue, and that's how they were addressing it. Now, we can pour through the evidence, and I can do it real quickly. You know, there's a timeline here. We've got Jerry Nichols, Carol Shepherds. They didn't think his situation was an emergency. They said he was sick. They couldn't confirm that Mr. Bruner needed immediate medical attention. Their concern really was the blood in the stool, which these folks knew nothing about. You've got an inmate here who said he saw Mr. Bruner for 8 to 5 days, and he was violently ill and vomiting, uncontrolled bowel movements. But we know that he was there for 1 day. That's what Exhibit 427 shows. When he was transported on the 4th, he got there at 11 o'clock. And we also know from Dr. Kirkpatrick and Dr. Petrie, and I don't know that anybody disputes this, that if you're that violently ill, given his underlying liver problem, he wouldn't have survived to the 10th. So what we really know is what the two objective guys say, hey, look, you look sick, we want to send you back, we don't think it's an emergency. And then we've got him transported in a van for 5 hours. And while he's in that 5 hours in that van, they said, we're not going to take a guy that's that obviously sick. And if he is that obviously sick, then they take him into booking, and they'd address it there. Mr. Bruner is clocked into booking in Wichita. There's no mention of him. It's because he wasn't obviously sick. He's placed in the cell in pod 1, where 3 separate deputies all are there looking at him for a span of 8 hours, maybe more deputies, and they don't note anything. It's because it didn't appear that he was sick. He was sick. Don't get me wrong. He had end-stage liver disease, a serious condition, a condition that ultimately led to his death. But he was not sick from the standpoint that it would be observed, and that's the difference. It's what could have been known. Well, wait a second. We've got a couple of inmates here. We've got inmate Yules. You'll remember him as the guy who wants the TV set. He's saying that Mr. Bruner is vomiting, coughing, not eating each day. We've got inmate Navarrete. He claims to have seen Mr. Bruner give away food, walk away from the cell slowly. He claims to talk to deputies each shift thereafter. None of them mention it at all. Now, it's a small point as to both of these. Mr. Yules, he was incompetent. Mr. Navarrete, he claims that he could see the people checking on his, checking out the Mr. Bruner throughout the day. Well, if you look through the exhibits, you'll see the diagram of the mezzanine level, and you see the lower level. And you'll see on the diagram, there's actually a blow-up, that Mr. Navarrete was above him. He had to look down through the floor to see what he claimed he saw. Of course, he initially said he was on the lower floor. He only admitted he was on the upper floor when I was confronted with cross-examination. Are these guys lying? Or no, they probably believe what they're saying, I suppose. But it doesn't make sense when you put it in the context of what we have by way of evidence. We've got all these deputies to say, no, we didn't hear anything. We've got the doctor saying, no, look, he wasn't that medically poor until later on. This is very fast action. You've got Mr. Fletcher saying, here's what I saw when I saw him. You know, it took the clinic, and maybe we want to say this is a bad thing. I think it just expresses what his condition was. It took them 6.5 hours, the trained medical folks who were there, who saw him after he got worse, after he was transported. It took them that long to figure out this is an emergency. These folks are supposed to know. You know, we've got Mr. Jameson here, Marque. He spent about 30 seconds to a minute with him in the morning of the 10th. Then he comes back and he helps him into his cell, maybe 2 or 3 minutes. He's supposed to know. Then we've got Mary Staton. She doesn't even spend any time with him. She's always in the booth. She sees him. If she needs someone, she has to send him out to look. Now, you say, that's wrong. How can that be? You mean you put people in a jail and you don't even check on them? Maybe. It's not my job to defend how the sheriff does that. There is a defense to it. My job is to talk about these two folks and doing what they did and what they know. Now, you'll see, if you want to look at Exhibit 428, if you want to look at Exhibit 429, that Mr. Navarrete, when he claims to have made observations, he says, hey, look, I saw this inmate, Mr. Bruner, placed in a wheelchair and moved up. You'll see that he wasn't even there to see it at the time. He was off at a professional visit talking to his lawyer. That's what this document demonstrates right here. Between 2:46 and 3:56, he's gone out of the cell, professional visit. So when you're deciding what's probable, what's not probable from their testimony, consider that. After 4 separate deputies in March 8th, they don't see anything reported. March 9, Deputy Duke, first shift, he sees Mr. Bruner acting strange. He says he thinks he's being bulldogged for his food. He makes sure that afternoon that he gets food. He watches him eat. He watches him come out and watch TV in the day room. Oh, but you know, he's just all part of this code of silence, isn't he? Do you believe that? Have they proved that? There's some suggestion, by the way, that Mr. Bruner hadn't been eating all along, and I'm not going to tell you that he had, because I think that we know that there have been certain meals where we can confirm that he didn't eat, and certainly that had taken place. But I don't think it's fair to say that this man was starving. We've got in Exhibit 2 a medical screening report where he comes in and they weigh him and they say he's 162 pounds. This is in November. This is actually a sheet I think they did it on. Again, 162 pounds. It's done by ConMed. And what we know from Plaintiff's Exhibit 1 is that he was 166 pounds in the autopsy. Yeah, the man was sick. But let's not pretend that it was something that probably wasn't. So then we get to Deputy Staton. Mr. Bruner is confused. She sees him walking around. She asks deputies to come in. He appeared to have a mental health issue. The deputies come in. It was not only just Jameson, it was also a Deputy Murphy who came in, and they told you their observations. He looked, unfortunately, like so many other inmates that are in there. After linen exchange, someone, maybe it was inmate Navarrete, says, look, Deputy Staton, I don't think he's been eating. He doesn't look well. So what does she do? She investigates it. She looks back into her log records, and then she and Sergeant Martinez and Deputy Jameson at about 10:26, they get together and they discuss him. And they say, look, let's check on him. Let's see if he'll eat this next go around. Oh, by the way, call mental health to get mental health down here, because that's what they thought was going on. And she does that, and the mental health social worker came in, Ms. Skelton. She testified, said, yeah, I received the phone call. I was going to see him that afternoon. They give him a tray. She makes special efforts to do that. She has an inmate help him on it. You saw that in the log records, and he doesn't eat. She logs it. She's waiting for mental health. Then someone, an inmate, again, maybe it's Mr. Navarrete, tells them that he's on the floor. So what does she do? She doesn't ignore it. She calls Mr. Jameson, says, come on in, check on him. He comes in, and what does he do? He checks on him. They still think it's a mental health issue, but you know, they've got mental health on the way. Nevertheless, what does she do? She calls Sergeant Martinez. And she tells Sergeant Martinez what she saw. Did she tell him that Mr. Bruner was laying there unconscious on the floor? No, because he wasn't. That's not what Mr. Jameson said. So when Sergeant Martinez says, oh, if he told me that, I would have done something else. Maybe he would have, but that was not the observation they made. They all thought it was a mental health issue. Mental health comes in. And what do they think? Well, Nurse Armstrong isn't sure whether it still isn't a mental health issue. She just wants to have him checked. She found him to be mildly weak, not responding in full sentences. Does she call Code 1? Does she say this is an emergency with her training? No. Nurse Skelton, she remembers that Mr. Bruner was sweating heavily and incoherent. She didn't call Code 1 too. Now, people's memories over time, they vary. Nurse Armstrong in her deposition, you may remember, said, well, I thought, my memory was that Nurse Skelton really thought it was a mental health issue then. But it is what it is. They got the medical attention. These folks got them the medical attention. They're there at 3. They then get him to a wheelchair to take him up there. They then take him to the clinic. You've got Sergeant Wooten who sees him, explains what they're thinking about. And when they're at the clinic, it's now around 4:10 or somewhere after that, the vitals are all pretty much normal. He's a sick man, but he does not appear sick. He's a man that Charlie Fletcher said, you got a liver issue here. That's what he's got. He's got end-stage liver disease that their experts don't talk about because it's not fatal. They want to talk about other things that didn't happen. You've got Deputy Jones, who saw some evidence of some pain and suffering. No one did that. You saw testimony from Nurse Nelson, who took the vitals and said, look, he doesn't look that bad. Then you've got Charlie Fletcher. He did not know that Mr. Bruner's condition was serious enough to send him to the hospital. He doesn't give him pain medication. He does not diagnose or see the pneumonia, the sepsis, or the meningitis, and that's, I think, because, as Dr. Kirkpatrick and Dr. Petrie told you, he didn't get all that until he's up at the clinic. Now, it's a condition that moves quickly. It's this liver disease that this gentleman had. It's a condition that he was going to die from, frankly, no matter what they did on the 10th. But it wasn't present and wasn't known by these folks. They find out about the blood tests. Maybe it was too late. Maybe they should have found out earlier. Probably should have. They're not in the clinic. They take Mr. Bruner to the hospital, and when they get him, he's dead. One of the things I was curious about is why Mr. Bruner hadn't been complaining. You know, there's no testimony, and I think actually it's just the opposite. There's testimony he didn't complain, although he had the ability to. Does that mean he's that sick? Well, that's one possibility, but here's another one. In Exhibit 20 that's in evidence, Mr. Bruner, back in 2007, about a year before this, states he's concerned about his liver, says he was treated at Wesley in January 2006 and has only half his liver. So we look at the records, I think it was really February. In February in 2006 at Wesley Medical Hospital, you have Mr. Bruner coming into the emergency room with an increased abdominal girth for the last 6 months. He reports diffuse abdominal pain. He says it's been there for 6 to 8 months. He's got swelling, 6 to 8 months. He went to the Hunter Health Clinic, which is also in Exhibit 19, and he went there in January just before. He can't control his bowels. Now, I don't know if that's 10 minutes. I think it's 10 months. Now, Dr. Kirkpatrick said, look, there's a lot of reasons you can be confused, and he obviously was confused at one point. One of them is the liver disease, the hepatic encephalitis. There's also a record, Exhibit 20. Mr. Bruner had been diagnosed with delusional disorder, and he had a Category 4 mental order, and he needed to be treated. You know, what this case boils down to, though, is some questions. I think it'd be interesting to hear what counsel's answer to these questions is, and I'm not going to tell you that I'll agree with his answer, and you'll have to, when you hear them, if he gives them, act for my clients. You've got the bird in your hand. You need to do justice. That's all we want. Think what the evidence is. But here's some questions that you might want answers to. Why would Mary and Jameson, Marque, deliberately ignore a medical condition? Okay. You saw these people. You can make that assessment. The judge tells you can figure it out. They were in here. You can figure out and size them up. Mary's a Girl Scout leader. She got a commendation for trying to save somebody's life who had suicide. You've got Marque, who's a big brother. They both contacted the clinic before. They had absolutely no reason to refuse medical treatment to any inmate, and there's no evidence that it had ever happened before. There's no, they'd be bringing in all sorts of witnesses if we had people here that had a character that they claimed. What's their motives? Are they really the monsters that he would have you say that they need to be punished and stopped? Not a big motive. The easiest thing to do, the lazy thing to do, would have been to call the clinic. There was no paperwork involved. They were never criticized for contacting the clinic. The clinic is there, available, fully staffed. So why didn't they do it? Well, the answer to these questions is what they didn't know. They didn't know he was that sick. And explain to them why they would do this. Explain to them what their motive was, because it doesn't exist. How do their actions line up with indifference, you might ask yourself? Let him tell you. Mary provided over-the-counter medication to other inmates on March 10. We know that. We went through those records. So she's just picking on Mr. Bruner. She contacted Sergeant Martinez. She called mental health. She arranged for a tray to be taken to Mr. Bruner to see if he'd eaten. She called in Mr. Jameson. She called Martinez again, and she notified her replacement when she left about Mr. Bruner. And they'll say, you may think, that's precious little. And maybe it is. But it's not being indifferent. Tell them they were wrong if you want. They know it already. I'm sure they feel bad about this whole thing. Tell them that they should have done better. But don't tell them that they knew. Don't tell them that they were deliberately indifferent. Don't tell them they're monsters unless you've got evidence of that, and there's no evidence at all. That's not right. It's not fair to them. Final question you might ask is, why would they do these things if they were consciously disregarding the risk to Mr. Bruner? Because, go back to that jury instruction, they've got to be consciously disregarding that risk. So what do we have by way of an explanation? And I think the answer is in the evidence. It's that they thought that he had a mental health issue. That's what they saw. That's what they believed. And with that belief, they acted appropriately, contacting, in Mr. Jameson's part, contacting Mary Staton and letting her know what he saw. Why did if he's deliberately indifferent, he goes out there at 2 o'clock in the afternoon, and there's a man in the cell. He can see it through the window. Why does he bother to open the door? Why go into the cell? Why pick him up on the floor? Why put him on his bed? Why go back and tell Staton? Maybe he just walks by. Maybe he doesn't even show up. Ultimately, they were wrong, and that's too bad. I mean, too bad's an understatement. That's awful. It's horrible. We all regret, and your verdict would not reflect anything different, that you regret that Mr. Bruner didn't get the care he wanted. Would it have made any difference? Probably not. But even when he was taken to the hospital, when he was found brain dead, they tried to give him care, and he was deserved at least that chance. No one disputes that. That's wrong to suggest otherwise. What's important here is whether or not in this case you have two deputies who have violated a constitutional right, cruel and unusual punishment. And that turns on, have plaintiffs prove these elements, and they haven't. When you deliberate, and if you reach the conclusions that are apparent from the evidence, I'm not going to tell you what it's not presumptuous enough, it's not from my position to be presumption enough to tell you what your verdict should be, but when you come back, and if you come back as I think you should, and that is find in answering the verdict form, no violation of constitutional rights by Mary Staton, no violation of rights by Marque Jameson, then you'll know that you've done justice. You followed the instructions. You've lived up to your oath. And you'll be able to look everyone in the face. And it will be an important day even then. Oh, you haven't given a huge verdict, sure, but you still have said, look, these people, these individuals, who they want to put this imprinter of horrible behavior on, they want to say these are monsters. They're not. And they can go about doing their job in the case, and they can get on with their life. I don't know if I told you at the beginning, I think maybe I did, but I want to thank you for your patience throughout. Like Mr. Feiger, gosh, it's a fear that a lawyer always has, that there's a question you should ask, something you should do. I don't know if I've lived up to the high standards of Mr. Feiger or others here. I've tried to do my job the best I can. What I do know is the evidence that you need to decide this case is with you. It's in those exhibits that you'll have, and it's in the testimony that you've heard. and when you apply them to the instructions, then you should find for the defendants. Thank you.
Any last words from Mr. Feiger?
Now here, at the conclusion of this case, I hear a story with little colored boxes in the last half hour that bore no resemblance to what I heard in this courtroom and what the evidence was. None whatsoever. And I'm thinking, is it possible that that justice could be that tainted? Let me just tell you, why did they do it? It was very hard to do nothing. You had to really want to not do something, because you would provide this kind of care to a dog, if you found a child, if you found a person. But to do it for minute after minute, hour after hour, and then say, well, gee, you haven't found, I'm in the Girl Scouts. Well, that's very nice. What does that have to do with what you did? To look at you in the eye and to say, you want to know the half-truths, never discuss the autopsy with you and say he died of liver disease? That's shocking. The autopsy's in evidence. Did Mr. Chalmers read you? He just told you over and over and over again he died of liver disease. Well, that's a kind of a shock. This is the autopsy, and this is the opinion of every doctor here, that this 46-year-old male died as a result of acute meningitis. The most likely organism is streptococcal pneumonia, consistent with the orgasms seen on the Gram stain. Meningital cultures grew out of Staph aureus, which may be a contaminant. The decedent was treated with antibiotic before his death and subsequent post-mortem examination. Massive brain swelling caused a herniation of a brainstem, most likely resulting in his death. There were other conditions noted on autopsy having nothing to do with his death. Also noted was severe bilateral pneumonia and end-stage hepatic cirrhosis. Oh, he died of liver disease, huh? Now, also, what the judge instructed you is you are to take these instructions as a whole, not pick out one and disregard the other. The first thing Mr. Chalmers did was read instruction 12 and say to you, ladies and gentlemen, the important part is the end. And without reading you the paragraph, the whole paragraph, he read you the last sentence of the paragraph. As to the second element, if you find the defendant refused to verify underlying facts that he or she strongly suspected to be true, or declined to confirm information about a risk that he or she strongly suspected to exist, you may conclude the defendant actually knew of a risk of harm of Mr. Bruner, had a serious medical need. Also, if you find that Mr. Bruner's risk of a serious medical need was obvious, you may, but you're not required to conclude the defendant actually knew of the risk. And then you read the final thing that says what he read. These are half-truths. Half-truths. In this case, they see a man who is dying, who within hours will be dead. He comes to you and says he wasn't starving because, look, when he was signed in, he was just 1 pound less than when they weighed him at autopsy. As if you could say that to people. He was filled with pus and fluid of bilateral pneumonia. He was swelled up like a balloon. Who in their right mind would come here and say to you, he really had been eaten, he'd only lost 1 pound? Who would say that in a court of law? Who would say you find a man unconscious, incoherent, within hours of death? Everybody's begging you, get him help. And say, oh, well, you're crazy, you're an inmate, you didn't see this, you didn't see that. How did all of them see exactly what happened? How does it all add up? And then just let him go. Because you know how it is here. He was really dying of liver disease, right? This didn't really happen. That's the prejudice. That's the cynicism. That's what I was talking about. That's what's going on here, the undercurrent. Because they were a batch, and the law doesn't apply to them. If anyone else did this, you'd understand immediately. If you locked your child in a room, you'd want him to go to jail. As the doctor said, if you did it in a hospital, you'd go right to jail. We need now to do justice, ladies and gentlemen. This wasn't a joke. It's not a game. It's not a lawyer trick. This really happened in America. It can't happen again. Thank you.
Thank you, counsel. Members of the jury, during your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic media or device such as telephone, cell phone, smartphone, iPhone, BlackBerry, computer, internet, any internet service, any text or instant messaging services, any internet chat rooms, blogs, websites such as Facebook, MySpace, LinkedIn, etc., to communicate to anyone any information about this case or to conduct any research about this case until I accept your verdict. When you have retired to your jury room, you will first select someone to act as your foreperson and to preside over your deliberations and to be your spokesperson to the court. When you have arrived at unanimous answers to the questions on the verdict form, you will complete the verdict form, have the foreperson sign and date it, and inform the bailiff that you are ready to return a verdict. If it becomes necessary to communicate with the court during your deliberations, you may send a written note to the bailiff. Bear in mind, however, that you are not to reveal to the court or to any person how the jury stands, numerically or otherwise, on the issues presented for your determination until after you have reached a verdict. At this point, you will return to the jury room to begin your deliberations. You will first select someone to act as your foreperson, and at this time, I'm going to ask that the bailiffs come forward and be sworn. Thank you. Court will now stand in recess.